Any mention?
Please, Your Lordship. Your Lordship, I beg to mention item number 32, Your Lordship.
Number
Number 32, Your Lordship.
32.
Yes, Your Lordship. Your Lordship, the conducting counsel is on sanction leave, Your Lordship.
Who's the correct counsel?
Mr. A.G. Momin, Your Lordship. I pray for 2 weeks' time, Your Lordship.
2 weeks, yes.
Highly obliged.
Your Lordship, I beg to mention item number 25, Lordship. Due to some personal difficulty, Your Lordship, I pray if this matter can be taken up after 2 weeks, Your Lordship.
20.
25, my Lordship.
My Lord, I have no objection. They have already priorly.
Yes. Yes, 2 weeks.
Duly
Yes.
obliged.
Your Lordship, I beg to mention item number 30. I pray for 2 weeks' time, Your Lordship.
Why?
The senior counsel is not present, Your Lordship, today.
30 what matter?
30, it's a teacher's matter, my lord. I am represented in
Some urgency there?
No, my lord.
No urgency.
It's a lot regarding this.
Yes, 2 weeks.
Obliged.
Obliged, Your Lordship.
Please, Lordship, I beg to make mention for item 18, Your Lordship. I pray the matter may come after a week, Lordship. 2 weeks, Lordship.
19 matter. Why Mr. Paul's on station now?
No, Lordship, is here, Lordship.
Yes.
Obliged.
Some more mentioning.
Lordship, I beg to mention item number 21 and 22.
20,
1 and 22. Lordship, item number 22, I'm the petitioner.
21, 22.
Yes, Your Lordship.
You have objection? No objection. Why? Where's your senior?
He's on sanction leave, Your Lordship.
I'm here, my lord. I'm busy.
No, not you. You the senior for other part, for the other party.
Oh,
Oh, he's on sanction leave. Yes. Okay, 21, 22. Yes. After
3 weeks, Your Lordship.
2 weeks, no 3 weeks. Yes. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 16. Lordship, in this matter, I would like to place one document which would be circumstantial in this case.
Which
Lordship. Which would be circumstantial in this case, Lordship.
What do you mean by circumstantial?
Lordship, there was an undertaking given by the petitioner in this case, whereby she has stated that if there was any excess payment or anything which was taken, that will be repaid back to the department.
Are you aware of that, Mr. Nakla?
No. Lordship, Lordship grants me leave to file this by an affidavit.
Yeah, you filed an affidavit. You concur to the submission that there's a fact that at the time when she undertook to return any excess payment.
I'm appearing for Regular Public Service Commission.
Oh, yes, Mr. H. Karmanlang, General Counsel for the state, submits that certain documents need to be brought on record which have a bearing in the case. Stop. Thereby, he prays for and allowed 2 weeks' time to file the same by way of affidavit. Yes, thereafter. Yes.
Lordship, I beg to mention item 29.
20?
29.
Mr. Charais was not here.
Yes, Your Lordship. It's a joint request from both the parties.
Okay, 2 weeks. Yeah. Follow them. Call up the list.
Supplementary list item number 1.
Please, Lordship.
What is there?
Lordship, this matter pertains to the border issue, Lordship, regarding the construction of the pillar in the border area between
Construction
of pillars.
Boundary pillars.
Yes.
Or
Yes,
fencing.
Fencing pillars.
There's a big difference between pillars and border fencing.
Border fencing, Lordship. In
What is your grievance?
Indo-Bangla.
What is your grievance?
Lordship, the brief background of the case is that, Lordship, prior to the prior to deliberation of the Bangladesh Lordship, this Nehru Noon Agreement 1958 was executed between the India and Bangladesh.
Before creation of Bangladesh, that means.
And then thereafter, Lordship, this in 1971.
No, tell me what is your present grievance? What is your grievance right now?
I agree with the guidelines, which was.
Where's the guidelines? What guidelines?
Lordship, come to Annexure 2, Lordship, page 45.
45.
Lordship. The operative part is paragraph 8, Lordship.
8.
8 and clause C, Lordship.
The border security forces both sides shall observe the following simple rules to avoid a possibility of unpleasant incidents. After the identifiable boundary line where the real working has been fixed, neither side will have the permanent or temporary border security force. How is this important?
Lordship, here it says that neither side will have any permanent or temporary border security force or any armed personnel within 150 yards or either side of this lane. No permanent post will be constructed till the final demarcation has been done.
So you mean to say that till now final demarcation has not been done?
No, Lordship. And they have gone to start with the acquisition process, Lordship.
Acquisition or construction of the.
They have construction and they have also start with the acquisition process also with the.
Where's the acquisition process?
Lordship, this Annexure 15, Lordship. There is that notification, Lordship, public notification.
Page.
Yes, page 112, Lordship.
112 is under which? This is dated 17.
No, 19, Lordship.
19th December 2017.
Yes.
Then why coming now?
Lordship, and because this issue has been going on, Lordship, has been continuing on and off.
Yes, Dr. Mosika.
A very convoluted way of challenging a land acquisition notification, my lord, after 6 years, my lord. Taking the plea of Indo-Bangladesh treaties, my lord.
And
without
Lordship, similar matter is also pending before this honorable.
Well, let us hear him first. Yes. Yes.
My lord, without making Bangladesh a party, and if Bangladesh is made a party, whether this honorable court have jurisdiction, my lord. So there are several aspects to the entire matter, my lord. I'll file a short affidavit, my lord. And
yes. Now another thing is that
for admission,
is a 17 notification under section 19(4) of the new
the
act.
Issues have been going
What
on
issues?
till date, Lordship, and there are several objections also which
Objection. What happened to objections?
By the Sardar, Lordship.
But the given rule is that from the boundaries 150 yards, 100 meters.
And then
It's
a minute of certain meetings also which were held in the office of the DC.
You file a short affidavit.
I'll file a short affidavit.
So issue notice. State anything to say? Others have now. Yes. Issue notice returnable in 3 weeks. Dr. N. Mosika with so and so is present on behalf of respondents number 1 and 2, and MHD NG Shilasin Advocate is present on behalf of 3 to 7, and
HDC is 108. HDC is 108.
yes, and KGC is represented by
H1
yes, Mr. H. Chong. Notice to issue to respond number 9. Mr. Dr. Mohit next submits that prays that he submits that he will be filing a short affidavit within 3 weeks, 2 weeks, just thereafter.
Highly obliged, Lordship.
Item number 2.
May I please, Your
What
Lordship?
is this, Mr. Yogan?
My lord, this pertains to a tender, my lord, where the bid has been called, my lord, for supply and installations of the lighting conductor system, my lord, in the Assam Rifles defense establishments, my lord.
So you are successful or you bid for the contract?
My lord, I am a contractor, my lord. I am a contractor. I have an experience of 23 years or 25 years
Very
of
good.
experience
Then
in
what happened?
supply. Now, my lord, the why we are aggrieved and why we are before my lord is, my lord, page 30, my lord, in this page 30, what they have provided in the tender is in the bid, my lord. It says that
Page 30.
30, my lord.
30.
30, my lord.
What clause are you challenging?
Clause, my lord, I will read later on, my lord, which are the clauses that I'm challenging. But first, my lord, I would like to draw my lord's attention here. It says that, my lord, any objection, grievances, or additional clauses otherwise.
Where are you reading?
The last, after the 14th clause, my lord, after 14th.
Yeah, okay.
Further, my lord has got further. Further, if any seller has any objection, grievances against these additional clauses or otherwise on any aspect of this bid, they can raise their representation against the same by using the representation window provided in the bid details filled in seller dashboard after logging in as a seller within 4 days of bid publication on GEM. Buyer would mean, my lord, the Assam Rifles here, my lord, is duty bound to reply to such representations and would not be allowed to open bids if he fails to reply to such representations, my lord.
What document is this you're reading?
My lord, this is the
the
bid
bid
document, my lord, is a part of annexure 2, my lord, P2,
Okay.
page 15, my lord. Now, my lord, page 31, my lord, this is the queries that I have raised after going through the bid, my lord. My lord, this may take little time, but kindly bear with me. I would like to read.
No, what
because-
is your main challenge? Challenging certain clauses of the
Yes, my
of
lord.
the bid.
Yes, my
of
lord.
the
Number
bid
one thing
document.
is, my lord, it's they have curtailed the criteria, the experience criteria, in total in against the CVC guidelines. Number one, where it says 4 years of experience in electrical supply, now it has a curtain to 2 years of experience. That is fine. But now, my lord, what they are saying is that all this equipment that has to be tested in the Middle East Technical Institute that is situated in Turkey. Suppose, for example, today I am supplying a gadgets or an instruments that is matching specification in India. I'll have to send it to Turkey, get a certificate from them, my lord. These conditions, my lord, why it has been done deliberately, this, to my humble understanding, deliberately this has been done to curtain already experienced
You mean
suppliers
to make
like
it
me.
tailor-made for some bidders.
My lord, this is what my content. I'm grateful, my lord. And also, my lord, there are so many other now site visits, my lord. Site visits. Now, it is not required for a site visits, my lord, at this point of time, my lord, also. And also, my lord, now what they're saying is that even an OEM can compete in this one. Now, OEM, my lord, they are the manufacturers, my lord. They don't have any experience in the installations, my lord. They're just manufacturers. Now they have made in such a way that even the OEM can compete in this bid, my lord. So apart, these are the without prejudice to all these points, my lord. I have page 31, my lord. Just details, my lord. Details, clause by clause inquiries has been done, my lord. This may I read, my lord?
Yes.
Page 31, my lord. This has been addressed to the Chief Engineer, my lord, Director General, Assam Rifles, Light Court, Shillong, Meghalaya, PIN, so and so. Subject: manipulation, conditions, and unfair selection process for GEM bid number so and so, dated 27/6/23, lighting conductor system, my lord. Dear sir, madam, reference to the tender of the GM bid number so and so for the lighting conductor system, it is totally favoring one manufacturer and bidder of the choice of seniors of Assam Rifles. The following discrepancies and irregularities were observed in the tender process. Number one, it has come to my knowledge that the tender under reference, which was supposedly designed and created to ensure fair competition among contractors, has deviated from the category guidelines set by GEM, Government Marketplace. The category in question is the early streamer emission lighting protection system Q3, while already exists on GEM. The registered buyers on GEM can procure this system, including accessories and installation costs, at price ranging between INR 31,000 to 70,000 per unit, with a total cost of approximately INR 1,25,000, inclusive of all taxes and installation charges. These prices are readily available in the market from reputed manufacturers, but this was ignored, and some special specifications are included which makes tender monopolistic and is against the fair trade practice as specified by the Competition Commission of India. The triumph card of tender arrangement is mentioned in chapter 4.28, wherein the mandatory site visit of 50% of the locations to understand the location and terrain, weather, etc. Now in such a rainy season and with disturbance at Manipur, how can anyone travel to Manipur? This itself tests the intentions of the tender inviting authority that no one can visit the site. Only those 3 or 4 parties will be given the certificate who is favorable to the seniors of the Assam Rifles and will support the favorite bidder. And the best part is that they may not visit sites also but will get a certificate at Shillong only. It is to be noted that it is the contractor's responsibility to complete the job, and in today's time everything is available in Google and sites of Soil India. So there is no need to visit a site contraction and is not liable for any condition. If PG will be forfeited and will be blacklisted. This clause is included to reject the bidders, and I am 100% sure even if our staff will visit this site, they will be asked to wait and no certificate will be given. However, it is for your information that we are working at the Assam Rifle site for the past 15 years and is much aware of all the conditions. Kindly remove this clause of the site visit as mandatory. The turnover asked for the OEM is double the value of the tender, while in other tenders, the engineering department, it is 4 times the bid value, even after similar GEM number so-and-so 2021, where the turnover of OEM was 4 times. The dilution of turnover is probably because the OEM selected by the department does not have 4 times turnover. Further, the cost mentioned in the tender document is approximately 4,12,500 per unit, which is more than 300% higher than the marketplace. Such a significant difference raises concerns.
Okay, Mr. Yuban, let me just cut you short there.
My lord.
Now, these clauses are challenging, like in the writ court setting, it's not a technical kind of assessment we're doing.
My lord.
So how can we discern that these tender clauses are offensive? You know the law regarding challenging tender clauses before even the bids are.
Yes,
I think you're aware of the law.
My lord. My lord.
It's very limited. You have to put up a very strong prima facie case that that there is.
My lord.
It is apparent on the record itself.
Yes.
That the tender clauses are offensive.
Yes.
Because in every case the employer has a right to frame the tender clauses.
Exactly, my lord. Yes. My lord.
And so if a bidder cannot meet the conditions, don't bid.
My lord, there is a CVC guidelines, my lord.
Doesn't matter, let them reply to that.
My lord, my lord.
But don't expect any interim orders, anything from the court at this stage.
My lord, day after tomorrow, it's coming. Let them reply it by tomorrow. Let it be day after tomorrow, my lord. They can, till then, my lord. Or till Monday, my lord. Till Monday, my lord. Let them have replied, then we'll have a final hearing, my lord.
My lord, first of all, my lord, the tender has been extended by another 10 days, my lord, on their representation, and we have relaxed the condition by which they are aggrieved, my lord. One of the grievances was that Manipur cannot travel to Manipur. That we have relaxed that condition, my lord. My lord, here my case is that they have come with unclean hands, my lord. My lord, they want to push for their patented one. They are supplier of one particular brand which is patented in France, my lord. This equipment cost 30 lakh rupees, my lord. 4 years back we purchased, because that time our requirement was for the purpose of ammunition depot, my lord, and transformers. So that time we purchased from them at the cost of approximately 30 lakh rupees per unit, my lord. Now this present tender is for residential accommodation, my lord, of Jawans and all in this bordering areas. Here we don't require that high quality and very precise high-tech equipments, my lord. So we have tendered for generic. We don't require any patented technology for this, my lord. The generic technology which is plentifully available. My lord, what has been suppressed by the petitioners, my lord, we have tendered for a system, my lord. It has 5 components, my lord. And what they are referring to is only that stick we see in the rooftop, my lord. Lightning conductor system has 5 components, my lord.
Yes.
And my lord, I have instruction. If they are willing to supply at 1,25,000 rupees, my lord, we can guarantee that they will be the lowest bidder, my lord.
No, we
Why
can't,
instead
there's
of
no
bidding, my
question,
lord?
there's no kind of guarantee now. The only thing is that as per the bid document, they have represented, but he have not replied to it.
My lord, I'll just point out one thing, my lord.
Yes.
The tender document, because this is a tender through GEM portal, my lord. Now through GEM portal, they have to submit, there is a window of 4 days period, my lord. My friend has referred to that. He has to submit the representation in the GEM portal. They have not submitted any representation in GEM portal, my lord. They send a letter by registered post, my lord, on 1st of July.
When was this bid floated?
27th, my lord. 27/06 June.
Now, my lord, the corrigendum has been issued, my lord. I can place the corrigendum, my lord. It has been extended by another 10 days because after corrigendum, they again have a window of 4 days, my lord, to submit representations.
Submit the representation.
If he has any further
If you agree.
Well, let my senior.
No, you submit. We don't have two counsels. If you submit from the beginning, sorry. Yes. Yes, what do you say, Mr. Yubin?
Well, this corrigendum was not to my knowledge, my lord. Now, my lord, if this corrigendum is given to me now, I'll need a day's time to take instructions on this, my lord.
You file a representation, let them reply to it.
Well, this happens through the portal, my lord. We are not required to send a corrigendum to each and every. We don't know who are the prospective bidders also, my lord.
No, we understand that, but if they have, they have a grievance, and if the...
my lord, they had the window of 4 days, my lord, from 27th of June, which they don't avail, my lord.
No, there's no question in interim order, because challenging clauses of tender, if you don't meet them, don't bid.
My lord, if they have...
every tender is floated, and the buyers have to have that free play at the joints also to determine what clauses they want to put.
Lord,
if that's the way everybody starts challenging, so that if you find any clause offensive, you start challenging it, and then that's deleted. Now what happened?
My lord, this tender, my lord, when they are saying from the Turkey certificates, my lord,
even that
in the past, my lord, in the past, they themselves have said that a Turkey and Chinese product will not be allowed.
No, now they said Turkey is not required. They said a generic product. If they say you don't need to go to Manipur, you don't go to Manipur, no?
My lord, let me take a day's time to get a proper instruction.
Otherwise, you file. Otherwise, don't explain interim orders because you will not state tender matters.
My lord, can you give me a day's time?
Mr. P. Owen, due to developments that have been submitted by the SGI, please that the matter be taken up tomorrow.
My lord.
Yes, list tomorrow.
My lord. Obliged.
Item number 3.
Please, Your Lordship. By way of this miscase, we are seeking the restoration of reputation with this dismissal.
Big grievance your client must have with you. It didn't appear on 2 dates, not 1 date. Second date was dismissed.
First date,
15/6, no one appeared.
I'm really sorry for the inconvenience caused, my lord, but then that day, my lord, I was in the other court. My junior friend also skipped the matter.
And you know something, Mr. Thapa, court waited for around nearly 10 minutes. That is why this order came.
I understand, my lord.
Otherwise, this court doesn't usually dismiss for default. But last date, no one is present. Then again waited for 10 minutes. None of Mr. Paul has plentiful juniors, but no one was there to make even a mention.
We slightly got disarrayed that day, my lord. That is why this inconvenience had happened.
My lord, only partial relief they are entitled to, my lord. Ultimately, maybe I'm not objecting to restoration, my lord, but they have to go to CAT, my lord, in the main case.
Doesn't matter. Let them pay a little cost to Malsa.
Thereafter, in the main case, they should withdraw with the liberty, my lord.
My lord, may kindly excuse them with the cost, because this gentleman he lost his father during COVID time, and my lord, they are already reeling under so much of loan and so on and so forth, my lord.
You will step in and do the needful. It's not due to the latches of the client. Yes, this case number 152/2023 in revision of so-and-so. It's an application seeking for recall of the dismissal order dated 7/7/2023. Passed by this court. Next one, Ms. Estapa. The counsel petitioner submits that the non-appearance of any counsel on behalf of the petitioner on a set date was due to unavoidable circumstances. Stop. But you said you caught a traffic jam here?
Yes, my lord. On that day, I missed it by a whisker, my lord.
Anyway, not a whisker. We waited for quite some time.
Correct, my lord. But I even, my lord, could not come during that period, my lord.
Virtually, so you couldn't come.
Till which your lordship waited. During the extended time also, my lord.
Tom, no? Such he prays that the matter be restored to file for the ends of justice. Stump. Dr. N. Mozika led this DI on the Prohibit has no objections for restoration. Next paragraph, seen the grounds as made out in para 3 of the application, which this court finds satisfactory. Accordingly, the OPC number 1 to 4 or 2013 stands restored to file. In the main case, in view of the order passed in this case number so and so, list this matter on.
Well, it can be disposed of today by granting the liberty to
today.
Tomorrow,
to approach CAT.
They'll come tomorrow.
They'll come tomorrow.
This is a matter tomorrow, subsequently list. Which department?
Botanical.
This is all Botanical Survey of India.
Main list item number 1.
Your Lordship, item number 1, the appeal is admitted with there is a miscase 2 of 23. This is for dispensing with the certified copy.
Where's the miscase?
Miscase 2 of 23.
How many applicants here in this one? In this cross appeal?
One, there is 47.
47.
47.
They have filed the counter.
Cross appeal.
Cross appeal. Cross objection.
Cross appeal was yes, same thing. Yeah, how many? 47?
Yes, Lordship. Marvelous same and 46 others.
Yes, sir. So note down MC bracket cross appeal number 2, 2023, cross appeal number 1, 2023. Next paragraph, there's an application under this application for dispensing with the requirement of filing of more than one copy of impugned judgment order and decree dated 17/3/2020. Stop. Next paragraph, Mr. Vicky Jindal as a counsel with so and so, and Mr. S.L. Narasimhan advocate on behalf of the opposite party respondents. So, as the order in question is already part of similar appeals which are pending for this court, this instant miss case is allowed, yes, and the filing of the third copy of the same is dispensed with.
Appeal may be listed for hearing after 3 weeks.
What happened to other cases?
Other cases are also I am coming here one by one. Those which some are all are admitted. Item 2 is admitted. Item 3
okay, wait,
is admitted.
just wait. In the main case, this is matter 4. No, is there any fixed date for these matters to come up next?
No fixed
date.
Item 4, Your Lordship.
One second, Mr. Jindal. Just go a bit slow because the similar matters create more confusion. Yes, number 1, in the main case, that cross appeal number 1 so and so, in view of the order passed. No, just nothing to write. Just write that certified filing service dispensed with in view of the order passed in so and so. Stop this matter after 3 weeks. Yes. Yes. Now come to number 2.
Number 2, Your Lordship, appeal is ready for hearing.
No other order necessary.
No other order.
Then the house will list after 3 weeks with so and so. Yes. Then
item 3 also, appeal is ready for hearing.
number 3, same order.
Same order.
Number 4.
Number 4, Your Lordship, there are 2 missed cases. FA 1 of 22, this is filed by my friend.
For
this is about the court fees problem. There was one order which he took it.
Now they satisfied the court fees.
No, Lordship, I'm yet to pay. Lordship will have to modify the previous order and I'll be able to pay the court fee. So before that, we've also filed a missed case FA 4 of 22 that relates to the valuation of, an objection was raised with regard to the valuation of the appeal. And we had not valued the appeal correctly. So we filed an application for amendment.
No, that amendment, Your Lordship, contains other things also. I have filed my reply. Just
this is for
1 of 22 may be disposed.
Okay, 122. And item 4, missed case number 1.
1 of 22.
Yes.
Missed case 1.
You not listed after 11th November?
No, Lordships were hearing it on the question of maintainability.
Okay. No, your prayer is it's a bit confusing. In the light, you've seen your prayer in the lights of the above portion of law. You see your prayer. Yes. Modified order 28/10/2021 and 24/2021, part of whereby the appellant is required to pay the maximum court fee computed by registry of this court.
How much he wants to pay, that's not mentioned.
Maximum court fee. Huh? It would be maximum court fee, 11,000.
Under which act? Under Meghalaya or under Central Act? To my...
See, because this court fee does not have any schedule for this, right? It does not have provision for computation of these kind of fees.
Well, it'll only be on the basis of ad valorem court fee. Whatever is the entire claim that we are seeking, the difference basically.
Right, yes.
It's based on the difference. So on this particular, in this particular case, for the difference, the ad valorem court fee would be 11,000 rupees.
Yeah, that's maximum. Is that in para 8 he said that? They didn't pay 11,000.
Your Lordship, only my submission is this, Your Lordship, it's not the Meghalaya Court Fees Act which will be applicable here.
No. What they're doing is they're paying maximum court fee.
Maximum court fees under which act?
See, Meghalaya court fees doesn't have, because what happened was when he brought the decision, that was governed by the Madhya Pradesh Court Fees Act, correct? And then later on he came to understand that the Meghalaya Court Fees Act does not have a similar provision for computation. Let them pay maximum court fee. We'll amend it to that extent.
I recall my learned senior had raised the objection that I had undervalued my appeal.
No,
and
that
court fee was not paid.
In
So
that
then
way,
it
Your
would be
Lordship,
for the
the
registry.
preliminary objection which I have raised in this appeal.
We forget about that.
That one by one he is taking away those objections. Anyway, so far this is concerned.
Then we'll settle it.
I have no problem.
No, we'll settle it. Otherwise, we'll just unnecessarily make. How many years you waited for the compensation?
2 decades.
Yes, so fine. Unless you want to wait 2 decades more, then you keep on raising preliminary objections.
With Your Lordship, I don't think another, by the end of this year, should be over.
Yes. This business application MS, this case bracket FA number 1 2022 in FA number 1 of 2021, correct?
Lordship.
Yes.
28/10.
Right. This is an application filed by the respondent by the appellant stroke applicant stroke respondent under 151 of the CPC for modification of order dated 28/10/2021 and
Only that, 28/10/21.
That's it.
Only for modification of that order.
Yes. Stop. The ground is set out for modification is that in the earlier occasion on a incorrect premise, a decision had been placed, namely, which is that decision? Indoor Development Authority
versus Tarak
Indoor Development Authority versus Tarak Singh and others, wherein it had been held that in the context of land acquisition matters, an appellant was required to pay court fee on the memorandum of appeal to the extent on which the appellant seeks to avoid high compensation awarded by the reference court under Central Act. Stop. It is to be noted that the said case is cited in the background of the MP Court Fees Act. Stop. Next paragraph, Mr. SNL CNG submits that this miscase has become necessary to correct the facts and law in question and therefore has sought modification of the order dated 28/10/2021 by undertaking to pay ad valorem court fee, maximum ad valorem court fee payable at rupees 11,000 only. Stop. Next, by Mr. P. Jindal, learned counsel for the respondents has no objection, as he submits at the interest of justice that appeals be expeditiously disposed of. So,
only, Your Lordship, within period of 2 weeks.
In this view of the matter, the order dated 28/10/2021. Where's that order? It's quite a long order.
Well, there is some confusion on my part. If Lordship will kindly have this miscase tomorrow.
Why?
Well, actually, I think I've misread this. It is not, Lordship said directed by the order dated 21/10/21 to pay maximum court fee of 11,000 as per my submissions. I had referred to the judgment of Indore Development Authority. Kindly give me just a day's time, please. Just kindly have it tomorrow.
This is matter tomorrow on the request of CNGA.
Then MC4 also may have to be tomorrow.
No, this, my lords, what's happened is this is an application
further
for
confusion
amendment.
confounded.
This is with regard to an amendment, and they were required to file a show cause.
We have filed.
By order dated 5/7. We've received it. This may also be heard on the next date.
Tomorrow, after 3 weeks.
After 3 weeks, my lords. Whatever is convenient.
Miss case number 4. Let it come tomorrow also. List this entire thing. This
Let it
item
be
number
over
4.
tomorrow.
Let it come tomorrow. Yes.
Then FA1 is ready for hearing.
F1
Item
3
5.
weeks. 6.
Item 6 is also ready for hearing.
After 3 weeks, yes. Yes.
And 8, there is a misapplication 14 of 2023. It is for condonation of 357 days. Last time he said that he has to file some mukalatnama.
No objection.
We will pass similar orders for condonation. You've seen those other orders? Order for condoning. We'll pass similar order.
Yes, MC 14 of 23. Delay of 357.
Delay of
357 days.
357 days. Okay. Yes.
I'll
Someone add to that. This case number FA 14. Hashim Bhatti. Earlier one case to yes.
Item number 7.
We have to file the objection we filed already, my lord.
Yes.
We have given the copy also.
We have received a copy today.
Yes. What? How many days delay?
831 days.
Yes. What is the reasons you have given? Where's your objection?
Has not been reached in the court, my lord.
Yes.
My objection is that respondent number 1 objection.
Where's the objection of Mr. Nath's client?
It's like history, my lord. It has been.
You mean you filed it just now?
Yeah, technical defect was there, my lord. So I
have received copy.
Yes, today.
Why delay of what 844 days? How do you explain it? Where's your condition application? The condition application. Yes, okay.
no proper expression has been given, my lord.
But your lordship,
Your suit was dismissed in 2013. Which date was it dismissed? 18?
18.
Oh, 18.
As per their application. And case was filed in the year 2007. 2013, that means case was filed, my lord. Original case was filed in 2007, and then it was again renumbered.
Only Mrs. case was dismissed. What was dismissed?
There's a miscase that you seek for an injunction. They did not pursue that. So it got dismissed in the year 2013. So this is the order they're challenging.
No, but is the title suit still surviving?
The title suit is going on. Right?
Then
they're challenging that order.
you're not prepared with the matter.
Sufficient cause has been cited in this.
It's
very clear.
Your lordship matter will be fixed for hearing after 3 weeks.
There's no question of hearing. We'll hear it. Latest matter on Monday. You come prepared. On the request of so and so, this matter on Monday.
Item number 9.
You see, you look at what is the sufficient cause, a very minimum sufficient cause or not for court delay. Otherwise,
Obliged.
yes, MSE 1 year. Have you filed?
Your lordship,
Why?
respondent 1 and 2, they haven't filed an affidavit yet.
You asked for 2 weeks time to file. Did you enter to the other affidavits filed by them?
Praying for.
Who has not filed?
My lord, I appear on behalf of Respondent Corporation. We have filed the affidavit, and the state respondent, which is represented by I Lingua, my lord. She's indisposed today. She has also filed all the affidavits, my lord.
All has been filed.
My lord, yes. On the last.
What about respondent 9 to 13, 16 to 18?
It has been filed.
All are filed? My lord, all the respective affidavits have been filed, my lord.
Then?
The last person was stayed.
For respondent 1 and 2, we haven't received copies of that.
That is not the court hearing. You've been served. Must be.
File, my lord. It is on record. She has already filed.
Praying for the 4 weeks time, your lordship filing already.
4 weeks time? You take 2 weeks. 2 weeks time is granted as prayed for rejoined affidavits.
Item number 10.
Wait, please, Lordship.
Yes.
Lordship, this is a contempt petition, Lordship, and as per the last order, we're supposed to take steps, Lordship. Steps have been taken. We're awaiting for the.
Respondent 1 and 2, Lordship.
The order has been complied.
Lordship, I'll file.
Okay. What's the matter about?
1 week time. Contempt. This is a village VC matter.
MNGRS.
Concerning the petitioner having 2 job cards to voter card, that matter. I'm appearing for respondent 3 and 4.
No, that's the thing, that you should let them work and you disregard the earlier job cards were given. That's all. Because they had 2 job cards, so when they married, they went to other place. So they disregard the other job cards and let them work under the 100-day scheme. What is the problem? Are they being allowed to work or not?
From running court block, it has been deleted, Lordship.
But are they have they been allowed to work in the new place they are staying?
Yes, Lordship. The BDO has instructed the village
Then-
also to
To
enroll.
take instructions also. Mr. H. Karmi is on appearance today on behalf of the respondent number
1 and 2.
1 and 2, and Mr. M. Nongpu on behalf of respondents 3 and 4. So service complete. They pray for and allowed 2 weeks time to file affidavits. This thereafter also.
Obliged, Lordship.
11.
Please, Your Lordship. I'm entering appearance in this matter on behalf of the petitioner.
For the petitioner?
For the petitioner, my lords. This is against the Union of India.
Who's P. Sonar and A. Joshi?
So they were appearing earlier. They have withdrawn from this matter. As the petitioner is challenging his dismissal from service by order dated 5/11/22, and he's preferred a writ petition. An objection was raised with regard to the maintainability of the writ petition, whether it would lie here or before CAT.
Right, okay, NEPA, yeah.
And they were required to file a written objection as well.
You filed it correct. You've shown that provision where you should go for CAT.
So I may be granted just 2 weeks' time to examine this.
Otherwise, it's under the Ministry of Home Affairs.
So any services which are governed by central service rules, they would have to be before CAT. I'll just examine it. Just grant me 2 weeks' time.
2 weeks' time?
2 weeks. Or a week's time, that's fine.
Mr. S.N. Submits that he is entering appearance today on being newly engaged in innocent matter. He prays for it's allowed 2 weeks' time to study the matter and to seek instructions.
Highly obliged.
12.
For the state respondent.
Yes, Mr. Khan.
1, 2, and 3.
Very rare appearance by you. Yes.
We need just 2 weeks' time to file affidavit.
What about number 4?
Private respondent.
We have taken steps, my lord.
Have you taken the status?
Status report, we have to get it filed before the GPO.
Mr. A. Khan Leonard, GA, prays funds allowed for the 2 weeks' time to file affidavit. Stop. Your name?
M.U. Ahmed, Your Honor.
Mr. M.U. Ahmed, on behalf of the petitioners, please be allowed to obtain the status of service for number 4 and file affidavit in the next date. Let's after 2 weeks.
13.
Same.
Item number 13 is connected.
Same.
14.
My lord, we are filing a rejoinder as per the last order. We are supposed to file the rejoinder, so we are filing it, my lord.
Rejoinder? Short reply, not rejoinder.
It is a reply, my lord. Now, my lord, there is a new development. A different set of people who has gone to the division bench, my lord, by challenging the virus of the act, my lord. That was dismissed by the honorable division bench. But that order has been challenged before the Supreme Court. And next week, my lord, I was informed, next week the matter will be listed for the Supreme Court. Can this matter be taken up after next week, my lord?
One thing is that by this case, it was not before this bench. Coordinate bench has issued interim order staying the investigation. Is that correct?
Yes, yes.
But the division bench never passed such an order. They allowed investigation to go on, but just did not be arrested with the leave of the court.
Yes, yes.
Now, what is the situation now?
No, it has been dismissed. The order, writ petition challenge by the virus of the act.
By the same Boston only?
No. Different. It was the secretary of the district council, former secretary. That matter is before the Supreme Court, my lord. And I was told, my lord, next week it will be listed. So can this matter be taken after a week, my lord?
Lordship, that would depend on Lordship to adjourn or not adjourn. But our submission would be that, in fact, as on date, this matter can be disposed of in line with the division bench's judgment, because what has happened before the honorable division bench is the petitioner before the DB went on 2 lines. One, challenging the virus of the act itself. Second,
the investigation.
Second, claiming that section 21 of the act was not complied with. In other words, according to that petitioner, he should have been given notice, etc. Before this honorable bench, before my lord, the petitioner is claiming that section 21 ground, is agitating that section 21 ground. So while dismissing the petition, DB touched on both aspects. said that virus cannot be challenged. As far as the second aspect is concerned, Section 21, Lordship may kindly look at the order. What DB had to say.
Lordship, my affidavit is there, Lordship. I have enclosed.
The judgment?
Yes,
Very
judgment
good.
also I have enclosed it. I will enclose the judgment, also the order of the special judge from the Tuda also is there in the report also.
Para 16 and 17, my lord. If I'm allowed to read.
Yes.
In para 16, in this case, a complaint was made in respect of certain matters involving the use of public funds. A preliminary inquiry was called for by the Lokayukta, which resulted in several other names coming up apart from the person or persons originally complained against. At the time of preparing the preliminary report, due notice was issued in compliance with the principles of natural justice to the petitioner herein, whereupon the petitioner claims to have made an oral representation after receiving the notice of so-and-so by presenting himself before the body charged with the task of making the preliminary investigation. 17. At the highest, the best arguable case of the petitioner is that the order dated so-and-so passed by the Lokayukta may have been without notice to the petitioner, same ground before my lord, and without affording the petitioner an opportunity of being heard. However, such notice causes no prejudice to the petitioner since the matter has been referred to the special court for the special court to file charge sheets under certain provisions. There is no doubt that the petitioner will be heard as summons have already been issued. At any rate, if there is any grievance in such regard or any infraction that the petitioner can rightfully complain of, this is not the forum for such purpose. It appears that a sham challenge, this is about the act itself.
Well, so, then there's nothing remains here in this case.
My lord, what I am saying, I am submitting, this order is before the Supreme Court, my lord. This order has been challenged before the Supreme Court.
Being before Supreme Court doesn't mean there's automatic stay or something.
No, I'm just saying, my lord, I'm praying for just matter to be listed after a week, my lord.
Okay, Mr. SD, please the matter be listed after 1 week, in as much as the connected matter whereby the division bench of this court has dismissed the challenge is pending for the Supreme Court. And that will be the matter, list matter for 1 week. Otherwise,
interim order may be discontinued, Lordship.
In view of the division bench's order, there is no possibility of the interim continuing.
Even if there was an order, my lord, they have executed it.
Obligation.
15.
Your Lordship, I'm praying for further 3 weeks' time, Your Lordship, to file the affidavit.
the second time's come. Ms. Srimthao prays for the Lord 3 weeks' time to file affidavit listed after and so.
Supplementary list. Hearing item 4.
May it please your Lordship. Lordship, I'm praying for some accommodation in this matter, if this matter may be listed next week, subject to your Lordship's convenience.
See, this matter is fixed especially today.
Lordship, he's having some personal difficulties today.
He's not in court.
Lordship, he's not here yet.
So MPC has no role otherwise also. Though they are arranged.
But MPC is the issued advertisement, correct?
Yes. But this case only revolves around interpretation of the word preference.
Preferential meaning?
The advertisement says, my lord, the candidate should be
preferably
masters in social welfare, my lord, and preferentially with some experience, my lord.
So both the candidates are masters in social welfare.
Both are masters. I scored higher in the test conducted by MPSC, my lord. I was number 1 in the select list.
Okay.
Now the number 2 in the select list has come and challenged.
What is your challenge? If you participated in the examination, correct?
Madam.
In the interview, then why are you challenging it? If you've taken part, you can't turn back now and challenge the conditions of adjustment.
But that is a general law.
Yes.
Now I have taken a due plea. The instruction issued by the government requires the MSW specialization in the field of mental health. That is one. Number 2 is
you are MSW specialized in mental health.
Yes, I'm specialized, and my friend is not. That is the condition.
Specialized in mental health.
Yes, And second is, my lord, the government instruction very clear that for 5 years experience. I have enough experience, whereas my friend doesn't have experience.
No, but advertisement says what?
Advertisements, my lord, that was the instruction given by the government. Now the advertisement issued by the MPSC, they say that
then no, you're taking up cudgels on behalf of the government.
Right.
What's the stand of the government? Is that correct? Your requirement, the requirement of department gave another requirement and the advertisement float is different.
Yes, preferably.
Then there's no case. You took part of proceedings, you didn't succeed.
The government has admitted in the affidavit that the qualification,
admission doesn't matter. Why did you challenge the advertisement at that point of time?
That was, my lord, the advertisement spell out that one. Nobody awares the internal communication between the state government and the MPSC. That was the ground. And the state has admitted that yes, qualification is specialization in nature.
But Mr. Changreso, the selection process is complete.
I
don't think...
Lordship is correct. There is general law. Once a candidate take part, face the interview and result is out. I cannot take a U-turn.
Suppose he had succeeded.
That is, my lord. That is the law. Now the exception is the, my lord. I have a citation.
Suppose he had succeeded. Would someone else come and say that that the advertisement is not in sync with the requirement?
My lord, I fulfill the qualification prescribed by the government. I'm not saying that I'm qualified only the qualification prescribed by the MPSC. The qualification is prescribed by the appointing authority, competent authority. Here, MPSC has deviated from there and issued an advertisement. That is the issue. So
you have the authority to show that deviation of the Public Service Commission was vitiate the entire selection process.
But there are few decisions, my lord, unless the government authorized the selection authority.
Let us see that. Interesting.
My lord, he participated pursuant to that advertisement, my lord. Now, after coming at number 2, can he take a U-turn and challenge that, my lord?
I will satisfy. So only my friend is not available. Otherwise, I will proceed also.
MPSC,
Friday or next week.
Friday is not a good day. All lawyers want to take the weekend off. It's not the court. You give a fixed date. MSD Cruz. Otherwise, one of you will have to prepare the matter. Third?
First is too far.
First, fair enough.
This goes to 2 weeks, my lord.
First. Now we are on 19th. No, we are looking at August. 19th is.
Anytime 26, 27, my lord. Subject to Mr. Paul's availability.
No, if Mr. Paul not available, also we are accommodating him today. Then, yes,
any day, my lord. 1st August also.
Yes, at the request of your respondent number, MSD Cruz, the council number 4, with underability of the senior arguing counsel. This matter on 1st August, a fixed item. Please come prepared.
Yes.
Because you have got a big hill to climb,
yes.
Mr. Chanai.
Let us finish.
Whatever little irregularities are there, once you've taken part in the selection process and the results have been declared, yes, and come out unsuccessful, you cannot turn around and say,
yes,
like there are these discrepancies and this and that, which, have, and the extent of vitiation of the entire selection process also has to be to such an extent that, it's...
we will satisfy.
Yes. Yes.
Okay. In this, item 17.
It's contempt, no?
No, this is red petition.
Who's the petitioner?
R. Majumdar from Guwahati.
What's the matter about Automazika?
My lord, this person is Assam Rifle personnel, my lord. He was arrested by Manipur police, my lord, on the charges of drugs, my lord. What he represents, my lord, his wife files an FIR that his husband is gone missing, my lord. We issued absence from leave, my lord, and he was dismissed on that ground, my lord.
He was dismissed from service.
Yes.
He had served for how many years? He's 62 years old when he brought the writ petition. How is that possible?
The matter is pending since 19, my lord.
Whatever it is. When was he dismissed?
2018. 18, my lord.
2018.
18.
What to do with these matters? None appears on behalf of the petitioner. Interest of justice, this matter after 3 weeks. In the event of non-appearance, next day the matter should stand dismissed. Not prosecution. Yes.
19.
Yes. Where's Mr. Guru?
Please, Lordship. Actually, I was ready to correct. Last time, Lordship has asked me to write document 1, document 2. However, Lordship, we have forgotten to reflect in the order. So, bench assistance.
Because it's just an observation, not to show your, what you call it, the negligence on your part. I said just mark the pages. You wanted to reflect the order, but the police has not page marked the documents
from the court record. We went to write it there. They said not allowed. However, Lordship, we have no objection to the regularization because we have been trying to.
No. At least those documents we have to rely on the documents, correct?
Yes, Lordship.
Then
the document
you want the court to look here and there without knowing the pages.
Yeah, pages is there only, Lordship, because we just file it as it is whatever produced by the.
You paginated yourself by your hand, I'm saying.
Yeah. It is there. Pagination is there, Lordship.
Is there?
It is there. It is there.
Pagination is not there. The last one you.
So for Lordship, maybe. Pagination is there.
Where's the state?
So Mr. Bhattacharjee was appearing, Lordship. Actually, additional affidavit. In my copy, it is there.
Where is it?
This is the we find it in the form of additional affidavit, Lordship.
May 2023.
Yes. Direction from the court as per the order 5/4/2023.
Where's the documents?
It is in the form of additional affidavit. This additional affidavit filed on the basis of the order 5/4/2023, where it says that Mr. P.T. Sharma, for the respondent number 5, is granted 2 weeks time to bring the same on record by way of an affidavit. So, in compliance to that order, we have filed this report, Lordship. It is not in this one, but it is in the form of additional affidavit.
Where's the other document you gave by hand? Last occasion.
No, this is the
same one as here.
Yes.
You sure?
Yes, same thing. This is the record, whole record, Lordship. We file it by way of additional affidavit.
Just see if it's the same. If the same document. Last time he showed that there was no pagination. Showed here.
Lordship, this is my copy, my lord. This is my copy. I think Mr. Guru is referring that order.
Just see if it's the same one or not.
He's referring the same, I think. It's the same.
If the same, just see if the same document.
Same document.
Last time Mr. Sangma showed something which is not paginated.
Same. I'll go there.
It's the same also.
To be in the additional affidavit.
Mr. Abraham, your stand is that you directed for advertisement, correct?
Yes, that I have taken a specific ground on para for my affidavit.
This one. This one. This is the one. This is mine.
Here's the affidavit. Lucky starting door. This by spawn number 1 to 4. Oh, who's appearing?
This one from Mr. Balasaji. Your affidavit.
Where you made the statement in the affidavit? At
State
page?
affidavit. State affidavit. State affidavit. Yours affidavit.
Page?
Lord, our affidavit is dated, my Lord, 16/3/2020.
I've got it.
What is the query?
My Lord, para 7 of our affidavit starts from para 4, in fact, my Lord, which is at page 2. Para 4.
Government affidavit.
My Lord, if I'm allowed to read, my Lord, para 6.
Right.
Yes.
My Lord, para 8 also we have stated in detail, my Lord. 8, in fact, my Lord, para 8, 9, 10. 11.
Yes. Anything else to say, Mr.
Will kindly see.
Yes.
Oh. Lord,
Yes.
If my friend makes a submission, then I'll make my
Yes.
submissions.
My lord, the affidavit filed by the state respondent, basically they have taken 5 grounds.
Yes.
Refuting my claim. First is underqualified.
Yes.
Apparently, Lordship, I have brought on record my metric certificate. So this point goes off.
Yes.
Secondly, authorised. That too goes off.
Your point is 86.
Lordship.
Yes.
Now, third is it was a leave vacancy, not approved by government. Those are the third and the fourth ground.
So, okay, leave vacancy, what do you have to say?
My lord, now these 3 and 4, entire 1, 2, 3 and
3,
4.
okay, one is underqualified.
Yes.
Second, overage.
Overage.
The third,
Leave
leave
vacancy.
vacancy. And fourth?
Indeed. Fourth is not approved by the government. And hence the present litigation also.
Yes.
Now they are relying on judgment of Uma Devi.
Yes.
It goes in my favor, Lordship, apparently. So I have nothing much to say.
Yes. That's it.
Throughout since my initial appointment, the managing committee, that the respondent number 5, had been making several representations and letters to the state government to consider my case. They have been remaining adamant silence over it. And eventually, at the fag end of my retirement, comes and take this kind of. My case is
only one part, Mr. Guru. Now you appointed again certificacy by created by one teacher when on leave, correct?
Yes.
Then the teacher subsequently never came back. Never came back.
Never came back.
Never came back. Then you appointed against another post.
No, the same post as assistant teacher, not as
not as a substitute teacher.
Lots of.
Okay. You appointed against the same post.
Lots of yes.
As assistant teacher.
As
and
being the senior most.
Approval was sought.
Lots of yes.
When? Just help the court with the facts. When were you appointed as
This is 18/5/2012.
18/5/2012. You appointed
Page number 16 of the additional affidavit filed by the managing committee.
Page 16.
Page 16 of the additional affidavit.
They sought for approval.
Lots of yes.
That was never forthcoming.
Never forthcoming also.
Okay.
Subsequent to that, again on 17/10/2016.
17/10/2016. 10/2016. Sought approval.
Page 14. Letter by secretary.
14/14.
Page is 1/4/14.
Page 14.
Letter. Go back. You refer to 18/5/2012 as page 16, and then you go back to 14.
No, sir. 17/10/2016. That.
Before my friend proceeds.
Yes.
My lord, on the last occasion when the matter was taken up, my lord, there was a request, my lord, that if all the annexures are made in order, my lord.
Oh, right, in chronological order.
Yes,
now I remember, yes.
So my submission is on chronological order, lords.
But the documents provided by Mr. Sangma are not.
Not. So, lordship, 17/10/2016, page 14.
Yes.
That was addressed by the Secretary MC for issuing necessary appointment letter.
Yes.
Subsequent to that, again on 5/2/2018, that is
Right, Mr. Sangma. You're trying to mislead the court with pagination. Now, because this court can't remember all the details, that's why. The direction was that you put in chronological order and give a list and give this bunch of papers again. Because now I see 16, your next page is a letter dated 2011.
Yes.
Then after that is you come back to 2012, then you go 2002, next page after that. It's not done. We're trying to help the court, assist the court in a proper manner. You come 2011 again, then you come back to 2010 after that. We didn't ask you to correct from registry. All this court asks, remember now, is that you make these papers in a correct order chronologically and give a copy to the court. So we can refer to the letters in chronological fashion.
Lordship, I misunderstood because I thought I just went to
you pay cost 10,000 now. You pay cost.
Lordship, I apologize.
This court does not approve of of trying to be over smart. That's the only thing. We are here. You are an officer of the court. You're supposed to help the court and not to hide under some excuse. That's not reflected in the order that I did not correct it.
No, actually, we thought we will be allowed.
Is that the way to assist the court? We're all here for one purpose only, remember that.
We are misunderstood.
Now remember what Mr. Balaji is correct. Now you come back, you come to your page 26. In this on page 1010, next page is a letter dated 1997.
My lord, if I may.
Is this the way you find affidavit also? Even if you prepared affidavit also, should have put it in chronological order.
We just put it the way the managing committee, whatever they present, we just.
You are what? You're not a lawyer. Who are you? It was very disturbed. It's like it's
If I may pray.
inexcusable.
I'll
You
take
pay a
the-
personal cost for misleading the court.
I'll take the initiative, Lordship.
Lordship, actually, there was an order. Just that there was an order only. They produced a record. Then after that,
It is your duty to at least flag the records and put in a correct chronological order. First page is 2012, next page 2016, next page 2002. I'm very sorry, Mr. Sangha.
Lordship, we
This was
allowed
not
to.
usually hard. I'm very sorry.
We are allowed to correct it, Lordship, because we put it.
You're not
in
going to do no such thing. Mr. Guru, you just put them in order and give a
Lordship.
copy to the court. Well, I'll pass and the order I'll record due to the this is matter on. We'll have to listen next week, Mr. Guru. This is matter on Tuesday. On Tuesday is the first. No, Tuesday is the 25th. This is a matter on 25th for the hearing is.
Lord, only humble request, my lord, if a copy is also supplied to
You
us.
can only give. You can correct it yourself. Yes.
I'll advance call.
Yes. This matter has gone on long enough.
Item 20.
Deeply open.
Lord, I have taken from the petitioner.
Yes.
To VC. My lord, the petitioner had applied for the post of constable in the Assam Rifles. So he was found physically fit. But on the medical test, the medical board of the medical officers of the authorities, they said that he has got some problem. And unfit because of high frequency hearing loss of right ear, my lord.
Yes.
So thereafter, he filed an appeal to the their own authorities, Assam Rifles, for a second checkup. So second checkup was also made, and somehow they have upheld the first one. Then again, the Assam Rifles authorities referred the matter to the Nigrim for a second opinion, my lord. And the Nigrim, why, my lord, page 20, my lord. 19 is the page 19, annexure 8.
Yes.
So its type copy is in the next page. Type copy, my lord. So in the third paragraph, my lord, it says.
Type copy is next page.
Next page, yes.
It's
Type
not here.
copy.
Anyway.
In
type
third paragraph, my lord. In my opinion, yes. It is there, my lord.
There's no type copy here, Mr. Siddiqui.
Then let us come to annexure 8 itself, page 19. Page 19 itself.
Yes.
So it says in the third paragraph, in my opinion, this is an error of judgment due to following reasons, my lord. So the findings of the medical board of the Assam Rifle, about that it was said, in my opinion, this is a error of judgment due to the following reason. DNS is not symptomatic and potency is. And number 2 has been connected and neo-tympanic membranes is intact and hearing sensitivity, which is pure tone auditory. So actually they find that it is not, because of error judgment, they have come to the finding that there is loss of hearing, my lord, in the right. But in their affidavit, my lord, on this point, in their affidavit, paragraph 8,
One second, let's just go to page 18. Unfit on account of high frequency hearing loss of right ear.
Yes.
Impaired tone audiometry, PTA. Now, what do you see here? Has been corrected and neo-tympanic membrane intact and hearing sensitivity WNC in peer tone auditory. Audiometry. Yes, yes. What affidavit?
My lord, Nigrim has come to the conclusion that this is the wrong judgment of the medical board, that he has got loss of frequency or loss of hearing.
He said it's
in the
been
right.
correct. It's been corrected. Yes,
But
yes.
In para 8 we said, my lord. In para 8 of the affidavit, my lord.
But in para 8, my lord, in para 8 of their affidavit, what they say about this Nigrim's thing, my lord, please come to para 8 of their affidavit. Page 6, paragraph 8.
Yes.
It says that with regards to the statement and averments made in paragraph 8 to 11 of the writ petition, the deponent denies the same, and it says that during RME on 12th October 20, the petitioner showed sign of injury in the ear as observed by the review medical board subsequent to the same. As per paragraph 7 of the Directorate General CRPF guideline dated 4th September 20, the petitioner was referred to Nigrim for ENT specialist opinion with reference to deviated nasal septum right and chronic suppurative otitis media right ear. During detailed examination by
Why do you send him to Nigrim's then?
My lord, he was sent to Nigris only with regard to certain aspect, my lord.
Why do you send him? If you say that the review medical board is final, then there's no question of any further review as regards suitability for joining service. But if Nigrim says it's been corrected, will not that make him fit?
No, but hearing loss is still there, my lord.
no, my lord, this is wrong. There I dispute, my lord. These words are not there in the medical report that he is suffering from high frequency hearing loss, my lord. These words are not there. I don't know where from they got these words. If your lordship can come again to page 19, my lord. These words are not there.
Where's the reference to Nigrim's?
Page 19 is addition 8, my lord. I again submit that these words, high frequency hearing loss, is not there, which they have said in their affidavit. If it is so, then I have got no case, my lord, if high frequency loss is there in the Nigrim's report.
No, does not mention where's the reference that you made to Nigrim's? Why?
They have said it.
That letter is not there.
It is the respondent who said it is in their affidavit itself. They said that she was referred.
Where is the reference letter, Mr. Siddiqui?
That reference letter. It's not here, my lord. They have submitted there itself with the authorities. And they have not annexed it in the affidavit also.
Where have we sent the affidavit?
Pleading, they have stated that it is.
Where have we sent the pleadings?
In the pleading of page, paragraph 18, page 6.
There's no para 18 in the affidavit, I mean.
Paragraph 8. Let me read paragraph 8, my lord.
You read it once just now and you went off to space. So
Yes, paragraph 8, page 6.
you've seen that. Where it says where's the review?
The review, my lord. Review is there in my petition. The review order.
See, this one, you see, however, Where is the government that after the review medical board he was sent again to Negrims on what premise or consideration?
So that they can explain. It's not there anywhere in.
And if you
They
maintain
produce
try to
that
maintain the
data.
ground that there's no other review medical board is final. Now why do you send them to Negrims? And if you send them Negrims also, you say the findings on a different medical condition, not on the one that's been referred. Because your concern is that high frequency hearing loss, and see that's not indicated even in the Negrims report. That means he still has that affliction. But then again in your affidavit does not reflect anyway why did he send him there and for what. He said despite you say that do you really be anticipate your Negrims? You see, as soon as the same as per Parasite direction, the patient referred to Negrims. Where's the direction?
That is
Para 7 of the Director General CRPF guidelines. Where is that?
May I pray for one this time?
See, Mr. Siddiqui, you kindly come to the 5th line of Para 8.
Yes. Para 7 of the Directorate
Subsequent to the
guidelines.
same, as per Para 7 Directorate General guidelines, it is for the patient referred to Negrims. That this court wants to see.
Yes. Yes, Lord. Let them produce the data.
You produce the guidelines, we'll see whether on what basis these guidelines, what is they prescribe and how these candidates are sent. Otherwise, when was he disallowed to continue? From
2020.
2020.
Yes.
This case is of
sir.
2020 also.
In the course of hearing, it is noted that the Directorate General of CRPF guidelines dated 4 September 2020, more particularly Para 7 thereof, is required for proper adjudication of the matter in question. Dr. N. Kalaja is ready to produce the same on an Excel visit up to 1 week. Once also. Nothing's happening today. Yes.
Item 23.
Your Lordship, I humbly pray that Your Lordship may kindly allow me to withdraw this petition.
You take instructions. Very good. Mr. S.K. Roy submits that on obtaining instructions from the writ petitioner, he prays without to withdraw the instrument application. No liberty. Yes. Accordingly, matter on the submission of so-and-so, matter stands closed on withdrawal. Yes.
24.
Lordship, the petitioner is praying for a direction that the intervening period between.
Why did you last time in the hearing? Why did you retreat to what question is the
respondent affidavit, page number 17. Your Lordship has done this,
what did it say?
That was counting of past service on reinstatement. So that is why this is not applicable. We were on last occasion.
The affidavit. Yes. Para 17.
Page 17. They have annexed the CCS pension rule 25.
Yes.
So why this is not applicable? This has come from Your Lordship. This is not applicable because this rule is relating to reinstatement of service when appeal or review. That is before the authorities. The case of the petitioner is that petitioner's order of dismissal has been quashed and set aside by this honorable court. Therefore, the petitioner is entitled for the back wages for the intervening period when he was terminated till his reinstatement in service.
You're seeking only back wages?
Yes, Lordship. And the
but has
and
that
for
period
treating
of
the intervening
your
period,
intervening period has been regularized by
yes.
the respondents as being on duty?
No, they have treated it as dice null. They have treated it as dice null, and no, and the rule.
So your only submission is that since it was not on appeal or review,
Lordship,
since it was set aside, but it's squashed on the question of technicality, right?
Technically, it was on merits, Lordship.
Let us see.
Yes. And of course, they were given the liberty to decide on the consequential relief. But
so that was
that
given a window.
Decision was never been forwarded to me. Never give a copy.
You mean to say that the liberty given by the court to decide any consequential relief?
Yes.
Cannot be overridden by the
yes.
By the
they
rules.
have to comply with in accordance with the rule 54A.
Of R 54E.
Yeah, 54E.
Okay.
And at no point of time this decision of treating the period of intervening period as dice null was communicated to me, and it was only after a representation was filed before the authorities a communication was made to the effect that the period has been treated as dice null and you are not entitled for this. The representation is page 35 of the writ petition.
No, 1 second. 1 second. So what's the appropriate decision they took? Page 35.
Yes. Decision of Lordship 2015.
No, 35 is a representation.
A representation, yes.
Yes. After what happened after representation?
After the representation, a communication was made. The representation is at page 35.
Okay.
It goes up to page 39.
Yes.
Yes. The representation was made. I may read page 38, the operative part.
No, where's the reply to your
The
representation?
reply is at page 40.
That will be agree with that, correct?
Yes, yes.
Yes.
So at page 40, annexure 6. May I read, Lordship?
Yes.
Refer your application dated 3rd September 2020. It is to inform you that you were enrolled in the Assam Rifle on 31st October 1999 and discharged from service with effect from 31st May 2009 afternoon, being an incorrigible offender by Commandant 39 AR order number so and so dated 31st May 2009. Aggrieved by the action of the department, you had filed WPC number SH 195 2013 in the Honorable High Court of Meghalaya, Shillong, seeking direction to reinstate you into service with all consequential benefits. The subject writ petition was disposed of by the Honorable Court by judgment and order dated 23rd May 2014 with direction to the respondent to reinstate the petitioner in service. The Honorable Court further directed to the respondents to start the proceedings if necessary de novo, and the petitioner should be given sufficient opportunity to put his case for defense. The department has filed writ appeal number 71 of 2014 against the judgment and order dated 23rd May 2014 on behalf of the Union of India, which was dismissed by order dated 22nd October 2014 with direction. The learned single judge has already granted liberty to the organization to start fresh proceeding from the stage it becomes vitiated, and in the premises discussed herein above, we dismiss the writ appeal being devoid of merit. In compliance with the judgment and order dated 23rd May 2014 passed by the Honorable High Court of Meghalaya in WPC number so and so or 195 2013, you were reinstated into the service. You had reported for duty on 30 November 2014, and the interim period of absence from 23rd May 2009 to 29 November 2014 has been treated as dice null by the department, as you have not performed any bona fide government duty during that period. Pay and allowances have been accordingly granted to you with effect from 30 November 2014 and the period of absence from duty with effect from 3rd May 2009 to 29 November 2014, which has been treated as dies non as per the direction of the competent authority on the general principle of no work, no pay, will have the consequential effect on your service benefits.
Yes. So what remains now?
So this is before challenge before your lordship.
Yes. Now show the court that the liberty given by the single bench at a point of time has not been acted upon and not acted as per the court's orders.
Firstly, lordship, the case of the petitioner is that he do not want to work. His case is that he wants to work. So he was prevented by the department from working.
That is not
number one.
See, that is not the what this court's asking you. What we're asking you is this. Now, the first petition you filed, it was judgment and order was passed on 23rd May 2014, correct? Now your dismissal discharge that aside is on technicality because by incompetent authority had passed the order, correct? But then, however, while passing that order, you see where annexure 2, right?
Yes.
You come to the operative part.
Operative part.
Yes, that is the last.
Page 25.
Yes. Start from para 10.
Para 10.
See. The only in para 9, the only consideration is that the court is not considered the respondent number 5 commandant is not a competent authority to pass impeded dismissal order. Correct, against that. And so that's why the court gave them liberty to restart proceedings if necessary, de novo, and you be given opportunity. It is made clear that there shall be no punishment or punishment or falling to the of law. And this very important line regarding the consequential relief is left open to the respondent to take appropriate decision. Now, then writ appeal was filed. Writ appeal was filed, didn't interfere. It said that enough liberty is given by the single judge, so it'll remain like that. Then you file your representation, correct? For representation, now you see that as per FR 54, and that period of, that when the dismissal order set aside by court of law, then when you are reinstated without holding any further inquiry, the period of absentee shall be regularized, and the government servant shall be shall be paid pay and allowances in accordance with the provisions of
54A.
54?
A.
Yes.
FR.
Fine. Now, how do you balance that against the order of the court which says that with regard to consequential reliefs is left to the authorities to do it? And after the representation, what they've done is that they've treated your period of absence as dies non, that intervening period, and on the principle no work, no pay. With regard to consequential relief, they don't allow you any pay and allowances. So how do you balance that against the court order, and you say that you're right, which has been given by FR 54?
Court order is.
Do you have any authority?
Yes, Lordship. The authorities
will not take much longer. Yes.
Lordship, 2015, Volume 1.
Yes. What does it say?
354.
2015. 1.
Meghalaya judgment. 354.
354.
This is a division bench judgment, Lordship. Para 8 will be very beneficial.
No, this is regarding promotion. Any other?
Para 8, the Apex Court in Union of India and others versus KV.
Where is that SCC, you said?
SCC, no, Lordship. It is Meghalaya judgment, 2015. Volume 1, Meghalaya judgment.
No, this is the This is a finding which is based on your case stands different footing. It come to court.
So here it is,
Any other
we are
judgment?
not much impressed by the contention advanced on behalf of the authorities. The normal rule of no work, no pay is not applicable to cases such as the present one, where the employee, although he is willing to work, he is kept away from work by the authorities for no fault of his.
It's not that you're not kept from, you were dismissed from service. And during that time you pursued litigation. And after litigation you were reinstated. With the liberty from restarted proceedings. They never restarted proceedings. They just took you back to service and paid you from 30th April 2014 or something. Yes. Next one.
Then Lordship, recently the same ground they have taken in a bunch of writ petition which were allowed by this Honorable Court by order dated, judgment and order dated 31st August 2022.
Which paragraph is
yes,
relevant?
Lordship, in para 17.
So that's the same thing. See, however, even if this court decided the petition to be reinstated in service, it is submitted, liberty may begin to respondent authority to decide. This is submission to decide the aspect of pay and back wages. This is the submission.
Final is 37, page para 37.
But they were given by the authorities themselves.
This contention of the respondent that no work, no pay is not also accepted.
In this case, what happened is that, notwithstanding anything, when they got back to service, they have been paid the pension benefit. They have already. Suppose that's the only case they were being paid. In your case, they said no.
Here, Lordship, in my case, only 54A is in my rescue. 54A. Rule 1.
Yes, anything, Dr. Mozika?
This.
Any other authority?
Lordship, in this only there's
in view of the court order existing, whether a statutory provision, as FR, will override the order of the court. If they've given it categorically there that it's a consequential relief that the decision.
The decision must be just and reasonable, Lordship, and that decision was never been communicated. Let them produce the record, Lordship. Never communicated. It was only after filing of my representation only they have given that my representation has been disclosed. That must
be a very material kind of objection.
But that must be communicated so that at that relevant point of time I could have challenged it.
Yes.
Or make a representation before the authorities. The records will be very necessary, Lordship. It was only in 2020 when I filed
representation. The agony. This order was passed on 2020 and it came to court on 21. Yes.
My Lord, first submission, my Lord, he was reinstated on 31/10/2014, my Lord.
Yes.
And he files the petition in the year 2021, my Lord.
Yes.
After enjoying the benefit of reinstatement for 7 years, my Lord.
Yes.
He was very cautious that time, my Lord, because
he was
the sword was still hanging, my Lord.
No, that
of fresh inquiry, my Lord.
De novo proceeding, liberty was given for de novo proceeding. So I cannot go to my employee and say that when you will start the proceeding, when you will start the proceeding against me.
A natural period of limitation when a person, 7 years is the cutoff. So anyway, yes.
My Lord, so that's my first submission, my Lord. After taking the fruit of the earlier round of litigation, my Lord,
yes,
and apprehending that de novo inquiry may be initiated against him, he waited for many years, my Lord, before filing the present writ petition, my Lord.
Yes.
So, my Lord, the writ petition suffers from delay and laches, firstly, my Lord.
Yes.
Secondly, my Lord, Justice TNK6 judgment at that point of time when he was directed to be reinstated, my lord. The same relief was claimed by him. No such relief was granted to him that time also. This honorable court.
That's reflected in the order.
Yes, my lord. It only said, my lord, the government will, the department will consider that.
Now the last line.
Last line, my lord.
Oh, that's all right.
26.
That we've seen.
My lord.
Regarding the consequential relief,
Consequential
it is
relief,
open to the respondent to take appropriate decision.
And we have taken the appropriate decision, my lord, that because he did not render any such service to the government during that period of time, my lord, he was treated as dies non and he was not paid, my lord. So, but that decision he should have challenged at that point of time, my lord. There is a substantial delay in challenging that one.
Lordship, that was never communicated. As such, this representation was the product that I have to file a representation, and upon filing of the representation, this communication was made.
Okay.
So had that and by which order this dies non was, the period was treated as dies non was also not communicated.
They thought that you were happy being reinstated, so they didn't take any further action. It was like a quid pro quo. You reinstated and no de novo proceedings. So you were happy also and they were happy also. They let him be reinstated and continue.
At least
then you turn around and say, I want other dues.
At least they should have treated this as in service without benefit, monetary benefit. At least for counting for the pension and others, voluntary retirement and others.
That's also
that could.
Now you change your prayer.
No, not changing the prayer, but they could have done it. Lordship. That should have been a reasonable view. But that intervening period is not counted in either in my service, neither I am getting the benefit, monetary benefit.
If you're agitated, then the delay goes against you, Mr. Patil.
Delay is not on my part, Lordship.
Of course.
Not at all, Lordship. Because the department was given the right to initiate a de novo proceeding. And I being an employee, how can I go to my employer and say that when you will start proceeding?
No, when you start. The more you instated, after maybe we can give you maybe even 2 years and say that where's my back wages and where's my qualifying service for the period.
And in the meantime, I have
and you filed your presentation in 2020 when you were instated in 31st October 2014. Anything else to say?
And that was not communicated at all. That they have taken this decision. This decision all are behind me, Lordship, behind my back.
Okay.
Your Lordship is not inclined to allow the writ petition. In that case, they may re-examine this representation.
Yes.
Re-examine it in light of the 54A.
Because you see, the other thing is that your matter was quashed by the court only a technicality. That also weighs in the mind of the court. That's the only thing. It's not a question that you being exonerated from, all whatever charges were there against you.
All the punishment was set aside also. The punishment was also set aside.
If it's by competent authority to pass the special order. But giving them liberty to restart a proceeding from where it stopped.
My lord, he's a person with 5 red ink entries, my lord. He should be happy that
5 red ink entries.
He should be happy that he's still in service.
He's still in service.
Because the commandant passed the order, my lord, he's been directed to reinstate, my lord.
That's his luck.
That is luck, my lord. So now more than that. 5 red entries, my lord, and 1 black entry. Total 6 entries.
How many petitions are there? Only one, correct?
Only one. He is.
I'll take down the brief facts of the case is that the petitioner, no, not what brief facts, the petitioner being aggrieved with the non-recognition of the period between 31/5/2009 to 31/10/2014, which is the date of discharge and the date of reinstatement respectively, is before this court querying for directions to be issued to respondents for regularization of his service for the aforementioned intervening period and to direct for regularizing the same for the purposes of pay allowances and increments. Stop. Next paragraph. Mr. S.C. Upadhyay, legal counsel for the petitioner, submits that the petitioner was discharged from service. You had 5 red ink entries, correct?
Yes.
Was discharged from service for getting 5 red ink entries in his service dossier. Stop. The said discharge was then challenged by way of the said discharge he submits was then challenged before this court by way of WPC number
195 of 13.
195/2013, and that this court by order dated 23/5/2014 quashed and set aside the impugned discharge order with directions to reinstate the petitioner service. Legal counsel submits that though the matter was carried on appeal, the same was dismissed. Stop. He's next paragraph. The legal counsel submits that in view of FR 54A, which stipulates that where the dismissal, removal, or compulsory retirement of a government servant is set aside by a court of law, and such government servant is reinstated without holding any further inquiry, the period of absence from duty shall be regularized. Stop. Legal counsel submits that he contends that in spite of the writ petitioner being reinstated to service on orders from a court of law, and there being no law, the stipulation as contained in FR 54-A has not been complied with for the purposes of rendering him due service benefits. He therefore prays that, or on another aspect, the council submits that the impugn order refusing the said consequential reliefs was not made known to the writ petitioner, and it was only after a representation had been preferred on
Presentation dated
on
3/9/2020.
3/9/2020 that he came to the knowledge that the said period had not been counted for the purposes of his qualifying service. He therefore prays that appropriate directions be passed in accordance with law for regularization of the same and for release of the due benefits to the writ petitioner. Next para. Dr. N. Mozika, DGSI, Register with so has firstly raised a question of laches and delay on the part of the petitioner. Has raised a question and submits that the petitioner was reinstated as far back as on 31/10/2014 and has only chosen to come before this court in the year
March 2021.
In March 2021 by way of the instituted application. On this ground alone, he submits, on account of delay, the petition deserves no consideration. On the merits of the matter, the Legislative Council submits that the order of the learned single bench dated 25/2014 had left it to the respondents, had given liberty to the respondents to initiate fresh departmental proceedings or to recommence departmental proceedings from the date of which it had been truncated, and to decide on any other consequential reliefs that the petitioner may be entitled to. So, he submits that, it is submitted that the respondents, though not having revived the dismissal proceedings, had, however, in line with the orders of this court, passed impugn order, whereby the intervening period of absence from 23rd May 2009 to 29 November 2014 has been treated as DIES non, with inverted small commas, DIES, then NON. Also on the ground that the writ petitioner had not performed any bona fide government duty. And on a general principle of no work, no pay, within single inverted commas, the writ petitioner was entitled to have any consequential benefits No, any consequence service benefits down. Any other submission?
And his termination was discharge was not set aside on merit, my lord. It was set aside on technical ground.
It's also been pointed out to the court that the setting aside of this discharge orders, dismissal orders, was not on merit, but was on a technicality that the authority that passed the dismissal order was incompetent to do so. He finally submits that because of delay and the decision that in account of delay and further on account of the reasoned decision that has been arrived at by the respondents, no orders are called for and the petition is liable to be dismissed. That's it. That's your submission, correct? I'll pass the voting part, other matters waiting. So anyway.
Item 26.
Well, this issue relates to the prolonged suspension of the petitioner, suspended in 2017, and still he's under suspension. And there is occasion where both the AHG and me argued for some time. I was relying on the judgment delivered by Supreme Court in Ajay Kumar case, whereas my learned senior AHG relied on the judgment delivered by the Madras High Court. Madras High Court.
What he is suspended? Why?
Suspension, my lord. There was allegation that I involved in the offence under the POCSO. I was placed in the suspension, and
you've been paid a substance allowance.
Substance allowance.
What stage is the trial?
No, stage of trial, my lord. It is still continue. Still continue.
No stage.
The stage. Evidence.
Evidence going on.
It is an evidence.
Evidence stage.
Inshallah. That is a admitted position.
Yes.
Lordship permission, if I may proceed. Or AG. AG.
Well, AG has some difficulty.
No, Your Lordship, because within this half we may not be able to complete it, Your Lordship.
It's not part-heard, is it?
It is not part-heard. Not part-heard.
Not part-heard, Your Lordship.
So what do you mean ground for challenge of this long suspension, and what is your main plank of argument?
Plank of argument, my lord, the Supreme Court in Ajay Kumar case says that the suspension cannot be continued after 90 days if the memorandum of charges is not served upon them, and if served upon him.
No, but are the parallel proceedings going on in the school?
No, Your Lordship.
Then, my lord, that is why that apex court order, according to me, it is in my favor. In my favor.
Whereas the citation?
I have annexed in the writ petition itself.
Okay.
Yes. It is started from page number 43. 43.
Ajay Kumar Chaudhary. But this decision has been deferred with. It's not a later decision, I think. There's not a decision that has gone.
If Lordship is pleased, last time
it has distinguished from this judgment. Another Supreme Court judgment is there.
Not by Supreme Court. If
Lordship, that is the Madras High Court judgment. Lordship is a full bench.
Where they have distinguished from this judgment. Yes.
Lordship, if Lordship
because this it may be per and curiam, because that's what it is said, that maybe at a point of time, the certain point of law was not brought to notice of the judge when this order was passed.
If Lordship is...
I've seen that Madras High Court judgment also where the AG relied on. According to me, my lord, with due respect, the Madras High Court held that Supreme Court did not lay down a good law in Ajay Kumar case. I have, my lord, strong reservation to accept that law later or the judgment rendered by the Madras High Court. Therefore, I want to, my lord, place that.
Interesting. You give the citation to Madras High Court?
Lordship, in fact, that has been.
Have you given a copy?
Lordship, yes, last time.
Is this
P. Kanan, Your Lordship, P. Kanan. If Lordship kindly come to para 25 of that judgment.
Because this Vikamjit sends judgment, something is para?
Para 25, Your Lordship. Lordship, before that, if Lordship kindly come to paragraph 22, Your Lordship. Paragraph 22, Your Lordship. Moreover, there are, Lordship has gone down.
Yes.
May I read it, Your Lordship?
No, we'll have it some other day.
Lordship, yes.
It'll take some time. Yes, when do we want it? This is a matter after 1 week of further hearing.
Yes. After?
So. They'll give the date.
Yes.
We'll try to complete it.
Yes.
It's only in this.
Then it'll come in the first week, somewhere first week of August.
Right.
7.
Apply.
With regard to the release of the seller, on our part we have released him, but the counsel for the petitioner is...
He's your best friend, where is he?
I have no idea.
It's by prior arrangement. It's not to the matter. He's disappeared. He still have lots of time, yes. Where did he disappeared? He was here?
He was here, I think he has just gone on ITO. I was not aware. Where has he gone to?
Well, he's missing for the foreign.
Okay, it's your lordship.
And you pay the cost for the restoration, since you're best friends. This is matter after so due to unavailability of the unconsent of the petitioner, yes.
Hello, pleasure.
28.
Lordship, this matter is fixed for hearing
on maintainability.
On the maintainability, so they should start. I have already given a reply.
Who's challenging maintainability?
We have challenged.
On what ground?
Lordship, because this is a private company, and 226 cannot be invoked. And second ground is that he has an alternative remedy. He has to approach the authorities.
Civil court authorities.
Civil court and
what is the matter about?
Even the administration, Lordship.
This is a scheme under the ISLA, which is an insurance scheme.
Oh, correct.
So yes, in my reply, I have pointed
where
out.
Is the objection to maintainability? Let us see the grounds.
My affidavit is dated 22nd August 22.
22nd August 22.
Para 4, Lordship.
Firstly on jurisdiction.
Firstly on jurisdiction.
Have you filed reply to this, Mr.
Yes,
Bhasan?
yes. The reply to that jurisdiction
No,
also.
okay, let us go to the
As per the article, which is the jurisdiction part, it does not say exclusively or only. It does say that it is somewhere in Hyderabad. That's the only thing. So if any dispute
Hyderabad means any dispute has to be settled in Hyderabad.
has to be settled in
That is the
that's the
registered
headquarter.
office of the
But
company.
it does not say only, because the petitioner has never been there. There was no correspondent that side. Everything was sent from here. It was during this intervening period during the COVID time. It was all by email, correspondence and everything.
Firstly, second point is jurisdiction. First point is jurisdiction. Second point is taken to be the question of facts. That regarding your deposit of the subscription fees.
Subscription is again your lordship. I've also pointed out in my writ petition there is no lapses in the payment of the everything has been paid. The premium, everything is. Now they
No, they
pointed out
dispute that. They say that there's no material evidence. In fact, it says no iota of material evidence which substantiates the payment of such subscription. Okay. Then
that
third,
again can be discussed at the time when it be heard on merit. So
Yes.
now on maintainability. So I've pointed out in the objection, Your Lordship, the IRDA, Your Lordship, is...
What about the Rule 12 of the ILSA, of that benevolent fund, provides that all disputes shall be initiated by administrative body of the fund in case not resolved, and General Council decide the matter in merit. What answer do you have to that? That he had recourse to air your grievances before the just whatever it's called.
Before that, Your Lordship, in the ISLA, the Article of Association of the ISLA, you could come to page 48 of my petition.
Just submit.
It says under jurisdiction, it says all the dispute suits against the institute shall be initiated in the state where the registered office to the institute is situated.
So where's the registered office?
Hyderabad.
Hyderabad.
Then why don't you institute in Hyderabad then?
Your Lordship, again, here the petitioner here is a beneficiary. She is claiming on behalf of the benefit that she is entitled being a nominee.
You would not cover all disputes.
This time, but does not say only. Part of the cause of action also arose here.
Right,
because
okay.
she received
that
an email.
we can also like sift it. But
She
another important point is, okay, that's on jurisdiction. Another important point is on alternate relief.
Page 53, Your Lordship. Page 55.
What does it say?
Rule 12. That all dispute has to be before the administration fund.
Have you approached them at any instance?
There's an email correspondent with them immediately on the demise of
email
my
means,
husband.
is it in the proper format that you have?
It has to be that way because it was during this COVID time. So the only way of communicating was by an email. So they have also replied to that email saying that I did not pay the premium. That is the only ground. I did not pay the premium.
Now what
for that
about
reason.
if then that's not resolved, then there's an appellate forum also, the General Council, which decide the matter on merit.
Understand?
This will bar you because then forget about Article 12 and private body and
by
all.
the last correspondent by the respondent. That's the only thing that they have given regarding the premium. They have not even mentioned in the email stating that I have to address, which should be a standard format in mentioning that if I am aggrieved by that, I could go to so-and-so forum, so-and-so authority.
See, you are a widow.
Yes.
And what is the amount you're claiming?
As per the 5 lakhs. It's also given
5 lakhs. So you say that your husband was a regular contributor to this fund.
Exactly.
Correct?
Yes.
And so by virtue, the money should come to you. So why can't we settle? Can we give a direction that you settle it within so and so?
If they can come under Rule 12, they can approach the authorities.
Yeah, we'll give a direction. Mr. Marpan just
approach
take
the authorities under Rule 12, Lordship. Within a time frame period.
Within a time frame, let them decide. In fact, whatever you set for in the petition, that can be decided. Then you won't have to go through the jungle of maintainability of marriage jurisdiction, Article 12, jurisdiction.
Because Your Lordship,
The remedy is available for him under Rule 12.
She'll need immediate relief.
Yes.
It's a question of engaging her,
because the premium was supposed to be paid, the balance amount is one.
Whatever is balance amount,
According
if
to
they
them.
cut short the premium, if the direction of this court that is be looked at, compassionately.
And also, as per the Article of Association, there is no such specific date which is given for the last.
That does not go there. The only thing is that what are you seeking in the end is relief for your client, correct?
Exactly.
And so, what will be the most efficacious way is that if there's a provision that they take it up and certain merit, then we can pass orders.
If they can review it, then yes.
Of course. I mean, we take instructions.
Yes.
We'll have it when today is Wednesday. Put it on Monday, then we'll dispose it of. No sense in keeping this matter pending. This matter on Monday. Yes, enable the council representative to take instructions. So that'll be the best way. You can give by email or whatever, let them reply. And
But
if you
again,
agree thereafter.
But again, by Monday, because it's all the way, because it's an official email, so it's going to take
No,
time.
Monday means you take instructions from your client. I'm not saying that you file it by Monday.
Okay.
I'm saying you take instructions whether that proposal is acceptable.
We'll explore that.
Otherwise, then we'll have to hear it. If your client wants that to go through the entire,
31?
Yes. Pension matter, Mr.
Yes, Lordship. So we have been paid
A
only
sad
till
story.
September 2022, Lordship.
What happened to all the tolls you're collecting, Dr. Mozika? Not using for paying pension?
It's a small amount. Lordship, in this case, primarily what we are asking is for the payment of our monthly pension, Your Lordship. We are not pressing on a GPF, leave encashment, and in fact, as per law, if our pension are not paid in time, we are entitled for interest, but we are not pressing for that, Your Lordship. The only thing
pension is a right.
Yes, Your Lordship.
It's not a largesse.
Yes, Your Lordship.
Yes.
So the only thing that we are before this honourable court is a monthly pension that has been due, Your Lordship. And we have mentioned here, Lordship, the...
See, Mr. Shila, we can't dispose of this matter like this because what are your instructions? You can't pay the pension. September 22, last you paid them.
My lord, as and when money is available, my lord, we are paying. Because there is a salary component also, my lord. We have to pay the existing employee's salary, my lord. Then what we were trying to just do it pro rata basis, my lord.
What is the financial implications? And as your pension bill every month you have to pay your ex-employees.
Should that we have filed an RTI and they have.
What is the pension? You know, the
as per this RTI, it is saying around 50 lakhs, Lordship. Page 40, Lordship.
Of your petition?
Yes, Lordship. We have filed an RTI and this is the reply, Lordship. We have asked how much do you pay for the pensioners monthly, Lordship. Here, paragraph 7, page 40, Lordship. Here it's written, presently the total expenditure in court for the payment of monthly pension and family pension is rupees. Paragraph 7, Lordship.
Is annually?
Yes, Lordship.
Monthly.
Sorry, Lordship. Monthly
is 50 lakhs.
50 lakhs.
Pension only, salary is
that means for 1 year around 6-7 crores, more than 7 crores, 8 crores. And your salary component?
Here we have not asked for salary.
You got last, why don't you try and settle some amount with them? At least pay them for September 22, now it's going to be September 23 soon. 1 year they can go without pension. How do you survive?
But the matter is kept pending. I'll talk to them with, even in tranches, if they can clear 2-3 months.
You have to clear in tranches, otherwise how do you survive? At least you pay them 3 months or 6 months or something.
I'll talk to them.
There are cases where, you know, pensioners, they can't even, you know, afford to pay their house rent anymore. Like, it is very unfortunate.
And medical bills also, Lordship, with their advance
medical
age.
Bills, house rent.
In fact, Your Lordship, we have approached them on 27 August 2021. From that time, they were telling us that there was no funds and everything, but till date, that is the reply that they given, Lordship.
See, like I said, pension is a right. Once you have taken, they've taken it to service. And
the matter is of deeper significance, madam. How the district council will survive, that is. Because when coal was there, madam, somehow.
It's not that also. Is the state also responsible for revenue sharing and releasing the money in time?
They have not dispersed their our share of royalty, madam.
State also has no money.
For that, let the dismissal come, Your Lordship, and we will reply accordingly.
You reply. Have you filed affidavit?
No, Your Lordship, because there is no statement against the state, Your Lordship.
No, how would they make statement against the state? But some solution has to come. Take down Mr. J. Shilal, counsel for the petitioners. Submit that the members of the petition association,
not association,
sorry, petitioners,
yes.
Needed petitioners have not been paid the pension since September 2022. Stop. It's also admitted that at this stage, not pressing for the CRG or other terminal benefits, but only that directions be issued for timely release of their monthly pension. Stop. Next paragraph. Dr. M. Mozika appearing for the respondents 1 and 2 submit that the situation of financial constraints as has been expressed on earlier occasions still remain, but that however attempts are being made to redress the grievances of the petitioners. Next paragraph. Mr. Nothing to submit, right?
No, you're not.
Yes. Ms. Enrique learned AAG with so and so submits that since no relief has been claimed against the state, he has no submissions to make at this stage. Next paragraph. The matter concerning the payment of pension has caused deep concern for this court also, in view of the fact that pensions are right and non-payment of the monthly pension for an extended period of time will surely cause grave hardship to the petitioners. Stop. Though this matter will still be kept pending, it is directed that the respondents 1 and 2 come up with a concrete proposal to at least release portions of the pensions due to the petitioners within a reasonable period of time.
This motion is respondent number 5 and 6, Your Lordship. 1 to 4 is stayed, Your Lordship.
Okay, 5 and 6 for whatever one and all the music.
No.
No,
no, Lordship. Mr. Counsel is 1, 2, 4.
You want
Mr. Counsel is 1, 2, 2.
1, 2, 3, and 4.
1, 2, 3,
Yes.
4, Lordship.
What is my fault if we still kept pending? It is directed that is pending.
State is 5, 6.
5, 6. We have 5, 6?
Yes.
In the order, let me just
Oh.
It is directed that respondent 1 and 2 come with a concrete concern proposal to at least release the pension of the petitioners.
No, for a certain period. For a for one.
In the order is shown.
For anyway, so Dr. M. Mozika to obtain instructions or to file affidavit in this regard. You can't let this go on. Then we have to issue corrections with the state to give some special financial assistance. Yes. Yes, after 2 weeks. Yes.
33.
Yes. MSCB Savian.
On the last occasion when this matter was heard, the counsel for the respondent had stated that they are still awaiting for verification report. As such, they cannot
What
process
verification report?
Because, Your Lordship, this is with regards to a claim of family pension by unmarried daughter.
The second round litigation is one.
Yes, Your Lordship.
Oh, now I remember it. What happened with verification, Dr. Mozika?
Madam, we have not yet received, madam. It's the latest instruction. Place it.
Shimon. What instructions say?
It says, my lord, the certain documents were issued by Lunglei, my lord, in Mizoram, which are without office seal, and there's some suspicious documents. So they asked for verification of those documents since last year, but till now there's no response to that.
From 7 July 2023.
My lord.
You going to copy to her?
Yes.
Yes, Your Lordship.
Just now you got them.
Yes, Your Lordship.
But
their client can also go.
You can just verify yourself also. Yes, if you can get in the instructions.
If she has somebody in Mizoram.
Only one letter. You have somebody in Mizoram, or is in Mizoram
I'll
itself.
have to
In Mizoram.
I'm
Is the
not
petitioner in
aware,
Mizoram, or
Lordship.
where is she?
I'm not aware whether she's in Shillong or Mizoram at present.
But I'm in contact with her.
Yes, Your Lordship.
Then okay, take down that Dr. M. Mozika today has produced written instructions dated 14 July 2023 that the matter has been kept pending due to non-receipt of verification for certain documents of the petitioner. Stop a copy of the said instructions also made over to the counsel of the petitioner, who will also seek instructions from the Tom. In that view, this is a matter after 3 weeks.
3 weeks, Your Lordship.
3 weeks, yes, to enable the counsels to obtain necessary information.
She can expedite the matter by going to police station in Lunglei.
Yes, you can do it. It's in her interest. She'll know what to do. Yes.